Please, Lordship. Lordship, on behalf of AK Purkashta, I would like to adjourn item number 1.
This 2018 matter, we are not inclined to adjourn. We are putting up all the old pending cases and you are seeking an adjournment. You could have circulated a slip yesterday. Time and again, we are telling you that please circulate a slip. Becomes easier. We could have listed more matters in the supplementary list.
Here,
Every time the board falls.
a brief accident yesterday night. He fell down while taking the.
Because in all these cases, where there are old pending cases, we'll like you to inform the client that you are taking an adjournment. Otherwise, we are unable to control the adjournments. Both sides are represented. On the prayer made by learned counsel for the petitioner, the matter stands adjourned today. Next matter is of the year 2018. The petitioner the learned counsel shall inform the petitioner. And the matter was adjourned at their instance. And a copy thereof be produced on the next date of listing. List after 2 weeks. You'll have to send a notice to your clients informing that at your instance, the matter is being adjourned.
Oh, okay.
Please, Your Lordship, I beg to mention item number 9. This is the matter of Mr. H.S. Sarkar. He is now under treatment at Hyderabad. My lord, may I kindly be passed over?
Who?
Mr. H.S. Sarkar. Matter of Mr. H.S. Sarkar.
Which item?
Item 9, my lord. He detected cancer, my lord. Therefore, he is under treatment at Hyderabad.
Okay.
May I kindly be passed over?
2 weeks. Both sides are represented on the prayer made by counsel for the petitioner. Matter stands adjourned today. List after 2 weeks. Okay. I was not aware there was illness. Okay.
May I please, Your Lordship, I beg to mention item number 8 for the adjournment. My
If
scenario
you
is
inform
out
the
of
same order, you will have to inform your client. Give them a letter and on the next date you produce a copy. Item 8, same order. Item first item. Inform your clients by a letter and produce the copy on the next date.
May please, Your Lordship. So I have to mention item number 6.
Item
6. 1.
6.
Yes, my lord. It will be common after dedication, my lord. Immediate after dedication.
Same order. You will have to inform your client that you are taking an adjournment.
Yes, I will inform my client.
Item 6.
Right.
And a copy of the letter will be produced on the next date.
Yes.
Item 6.
Mr. Lordship, I beg to mention item number 7, Lordship.
Item 7. Same order. You issue a notice to your client informing that you have taken adjournment. And 7, same thing.
May I please, Your Lordship? I beg to mention item number 12. Kindly list it after winter vacation.
Same order. Give a notice. We will come down heavily if notice is not given. Item 12. Give notice and acknowledgement should come on the next date. Produce it on the next date.
Item 2, daily list.
May I plead Your Lordship? My senior code number top of the list, first item. Please pass over for time being. My Lordship.
Item 3,
Item 3.
Mr. Krita, please go through the records. Let's see if we have anything. Records.
Hey, please, your lordship. Item 3.
3.
Lordship, contested matter. Insurance order is at page number 51, Lordship, dated 16/7/18, Lordship.
Yes. Where is the opinion? Which page is the
Lordship.
opinion?
Lordship, impugned order is at page number 51, Lordship. Lordship, in this case, the petitioner, after receiving notice, appeared before the tribunal and filed his WS, and he adduced his evidence as DW1. DW2, Lordship, his father, Moy Hussein, Lordship, and DW3, another neighbor of the petitioner, Lordship.
Nine. 1, 9, 8, 6, 7, 12. 2, 3, 4, 5, 6.
Father's deposition is Lordship, page 42.
Can do. Do it, do. Oh. Directly. Report. Display to be. Okay.
Verification officer's report is almost.
Yes, what is wrong with the judgment? The opinion?
Chip.
Your 1970 and 1966
Yes, voter list of
were rejected. Rightly so, because these were not proved in accordance with law.
66, 70 lordship, grandparents' name appeared. And
No, it is there, but it is not proved.
yes, yes.
This is not proved in accordance with law.
not Exhibited for the tribunal lordship. Actually, they applied for the certified copy of the voter list of 1966 and 70, but they did not provide. That's why they not exhibited before the tribunal lordship.
No, that can't be believed because there's nothing on record to show that you have applied.
Lordship, kindly see father's deposition. And lordship, after marriage, lordship, petitioner lived with her wife at his yes, lordship. Lordship, kindly see father's deposition. Father is still alive, lordship.
You see, the requirement of law is to prove that he was in India after 1925 to 1971. So if the voter list is not proved, how do you establish that he was here? If father is alive, gave deposition, that is okay.
Lordship, his name along with his father, lordship, voter list of 2013, lordship, page 27.
No, madam, you have to first come to the first point first. Any document which is after 25/3/1971 does not establish unless you show that you are a
Birth certificate, lordship.
you are a person born out of a person who is a citizen of India. The birth certificate is of 1983. Presence of your father who deposed as DW2 must be established prior to 25/1971.
Lordship, 2022 3 GLT, page 816, Korimali. Korimali, one citation is there here. Mother's deposition is here, lordship. 2022 3 GLT, page 816.
813
816,
6.
Korimali. Exhibit G, lordship, page 16, birth certificate of the petitioner.
Yes, this Karim Ali, which paragraph?
Another thing, Lordship, verification officer's report is almost blank, Lordship.
Hmm?
Verification officer's report is almost
So in
blank.
this, which paragraph you are relying on? With this 816 Karimali, which paragraph you're relying on?
Paragraph 3, Lordship. Name
Para?
Paragraph 3, Lordship. After a reference was made and notice issued to the tribunal, the appeared before the tribunal and filed his uh, written statement and produced a number of documents. The petitioner examined himself as SDW1 and his maternal uncle, namely Maharaj Ali, SDW2, his mother, namely Kodbhanu Nessa, SDW3, and his younger brother, namely Abdul Quddus, SDW4, to substantiate that the petitioner is an Indian and not a foreigner.
No, you are reading a part of it. You see, in this case, what had happened was the father of the proceedee, he appeared in the intermediate examination and those documents were proved. So that evidence is of creates a document of 1968, and therefore the deposition of the father was believed. We are not finding anything to connect you to your parents who were here in the state of Assam or anywhere else in India prior to 25/3/1971. Where is your written statement?
Written statement, Lordship. Page 30, Lordship.
The record.
Yes, Dr. Rao. No, it's not using that.
It, my document opening ध्यान चाहिए Indian citizen है yes बिल्कुल not करना ये report no document produced voting letter देखना है format correcting reference SP itu kod ko SP city ko itu my yes no reference no is in the case and for the same then back opening Turn back. Episode is 35. Yes, 358. I'll connect 358, 35, 37. Put my button. গন্ডগোল আছে জানো? এগুলা পুরো correspondence বুঝলো? About this, the reference to pending rules, case reference in connection with the investigation, so 298, no 16. As per the court of lecture will be, I was reporting this photo. It was initially in 2005. Yeah. What he said. On the period of the case report, this found that there is no reference number exists. Unless this return from SP office. It is
Because this
Think
is
that
the
this is this
reference.
opinions pronounced. Okay, we can do this. Is it okay, number two? Opinion of this. It appears when the police station number 35, serial number 358. This is reference number. If it is 57. It is input for right. Represent 35, 57. The forwarding was given in 2006. Given to 2006. Mr. Kalita,
Not same.
you've seen the reference?
Reference, let's say, I didn't check. I've checked the other things, but the reference, since there was no argument on that, so I didn't check. I'll just have it. I'm sorry, Lord Sylvia.
There's no reference by the Superintendent of Police. Form A says nothing, Form B says nothing. Now you see what happened was that the order sheet will tell you that this reference which was made did not even have a number. So after the evidence was over, you'll find on the order sheet 2018, the matter is sent back to the SP that it does not have a number. Then they write that number in the reference and they send it back. Look at the order sheet. No, left side. No, left, you in your hand. Next page, second last order. Yes. Now they give a number, correct? That document is at the end of the record. 3 or 4 pages you'll find. SP's letter. No, in your hand. Yes, that page. SP's letter. You got it?
Yes, Lord.
Now this number is still not available in the record. The reference number contained in the opinion 358-35/37.
Yes, Lord. I don't have it.
Now in the reference you will find in the reference document you will find at the top some numbers.
Yes, Lord, 35. Yeah, Lord, see that the letter to this SP, the letter to the SP, Lord, see here the two numbers are there, the PS
No,
number.
it was not there. That means your certificate handwriting is different. It was not there, therefore it was sent back.
That's true, Lord, see.
So that 35 we find serial number 358 is available, but
Yes,
37 is not available.
37 is not available.
And where is the letter of the Superintendent of Police? The reference itself will fail.
Yes, Lord, see, yes, that format A and B is there, but like this thing is not there.
SP's forwarding is not there.
There is missing. Lord.
SP reference document is another act of reference.
Otherwise, the 37 means lots of 37 Goalpara East. That is like ERO's number. That has been mentioned in the letter of SP. the 37 they have put in, that is ERO's number. So
ERO's number.
ERO's number. 37 Gwalpara is the ERO's number, 37. That's why they have put ERO. The SP's letter is there. So they have mentioned about this. The only thing is that Lordship, SP's reference is Lordship, I could not get it here.
In the LVO and the forwarding also is not there.
LVO forwarding
It doesn't
is,
say that they suspected to be a foreigner. That tick mark even, they have saved money for the state.
the formative format is there, but like,
No, ultimately they have saved money for the state.
here Lordship, this formative LVO is signed, but that format is there, but that forwarding letter is not.
No, tick mark is also not there. That whether you suspect him to be a foreigner doesn't tick mark. So he's saving money for the state. Can't help it, the matter must go back.
Or
Because
Lordship,
if there's
can
no
accommodate
offense-
us for a couple of weeks, then Lordship will try to find out if there is some record there as far as reference is concerned.
No, because if that reference is not in the record,
It's
we
not
can't
there.
permit you to.
It's
we can
not there,
really-
Lordship, that's correct, but like if there is something there on their record, they have somehow missed out. That's only we can find it out, otherwise there is nothing, Lordship. From here, Lordship, the Lordship is very right that this is not there. But if sometime happens, Lordship, the record lies there, somehow it is got missed or something like that, then we can bring it.
No, even if you bring it, the original determination has to be made by the tribunal.
No, but then it means like the reference is already there. Only thing is that the paper was missing, and like they have been given all the opportunities to appear. They haven't raised this issue also. Lordship. Before the tribunal, they haven't raised this issue. They didn't have any objection to this. So that will not prejudice them, Lordship, as such.
No, but if there is no, you see, even after trial, if there is no, let us say we hear a writ petition, if there is no writ petition at all, then what?
Lordship, I understand Lordship's anxiety, but like Lordship, here also that Lordship, there is no prejudice caused to them. They haven't raised any objection, nothing, Lordship. Only thing is that the reference page is
No,
not there.
absence of reference is that for that purpose you'll have to advance as an argument because the reference itself is not there. Question of prejudice
The other documents are there.
will never arise.
So all occurred, the documents are there, Lordship. I mean,
No, there is a presumption that there is a reference.
the ERO reference is there.
No, but
There
there,
is a, the pleading they have mentioned. Yes, sir. Petitioner states that.
my sister is pointing out page 11.
15, they have raised this issue.
Where are-
15 of the petition.
Read petition. Read petition they may have, but like they should have raised this issue.
Earlier it is not raised.
They haven't raised there. They have, I have gone to the WS, they haven't raised them.
Copies of the documents were not provided as per order 1964.
Lordship,
Copies of the documents along with the notice were not provided as per.
the notice like documents are not
No, no,
required to be
ground,
sent.
I think
Ground will have to be said. That ground itself doesn't exist.
No, Lordship, as far as notice is concerned, the notice itself is a ground. That's it has been
some of
settled.
the main grounds were not provided.
That is not required to be given, Lordship. That is not required to be given. That is not required to be given.
So the-
The main grounds are, I mean, there is only one, Lordship, that has been already settled. Saying that notice itself is a ground. There is no separate grounds has to be set.
No, Supreme Court has clarified now.
No, the ground, Lordship, he is a foreigner, that is a ground, Lordship.
Where is that?
I mean, he has been said that you have been suspected to be a foreigner for this stream, particular stream. That is the ground, Lordship. Other than that, Lordship, there
You
is
see,
no.
the tribunal is manufacturing a ground. There's no document by the either by the LVO or by the referral authority alleging him to be a.
Problem, Lordship, happens is that, as Lordship, why it is blank is that they do not provide any information. If you ask them the name also, they will only give you the name and like, they do not give any document. They keep mum.
But see, you see, that's okay. But something has to be filled up.
I agree with your Lordship that like they should have at least filled up yes, no. That Lordship, that
Yes,
they should have
But
done,
the
definitely. Lordship.
presumption of a reference cannot be there.
That was a lapse, Lordship. I cannot defend them, Lordship, on that. That was a lapse, Lordship. But as far as like keeping blank, Lordship, what happens? They do not give any information. And if you ask for them documents, they will always given time, 15 days time to give the documents. They don't come up with the documents. They just run away from there. That is the problem. Lordship may kindly accommodate me for some time. I'll just try to find out, Lordship, if something is there. At least, Lordship, they are not prejudiced. They have been given a proper trial. They have tried to bring in all those documents, whatever they wanted to. There was nothing, happened in that. Only thing is that technical difficulties is the difficulty is there. That is of course, Lordship, I agree with your Lordship.
Because both of us come from the trial court.
I understand, Lordship. I fully agree with you.
The
Like,
difficulty is-
like I can't put in much of argument before both of your Lordships. I fully agree with you. I understand, Lordship. But Lordship, if gives an opportunity,
it's
we'll try
a-
to find out like if something is there.
It's a default habit of looking at the order sheet and then proceeding.
I fully agree.
Never even come to,
I really appreciate that, and I fully agree with you. Lordship.
Remand by Lordship already 2018 matter.
no.
Otherwise, Lordship,
on
they
merit
don't
you
have any
a case
documents,
at
Lordship.
all.
There is no case in the merit, Lordship. There is no
Merit
case
you
in
don't
the
have a
merit.
case at all.
There is no case in the merit, Lordship.
You see, we both of us take pride in telling, in reminding ourselves that we have what you call an experience of trial court. Unless you have that experience, you'll not be able to understand what we are referring to. It should have been your submission first.
Correct.
On merit, as it stands today, you don't have a case at all.
On merit, Lordship, in my humble submission also, there is nothing. Lordship. There was nothing in this matter.
Okay, both sides are represented. On the prayer made by Mr. A. Kalita, learned counsel for the FT matters, the matter stands adjourned today. List after 3 weeks. Ensuing winter vacation.
Much obliged. Lordship.
Item 4.
Well, I'll just record it. Otherwise, on the next date, I may forget. Just
The
let me see.
reference is missing.
The document relating to the reference made by the Superintendent of Police border is not available on record. It also appears that after the conclusion of hearing, comma, as the reference number was not available in the record, comma, the learned tribunal had sent back the records to the Superintendent of Police border. And thereafter, the reference number was provided. Full stop. Then this last, so
Item 4.
Please, your Lordship. Here the impugned order at page 59. Annexure 15. My lord,
just a moment. Where is which page is the opinion?
my lord, at page 59.
59. This paternal uncle, did you introduce him in your written statement?
My lord, paternal uncle, my lord, in written statement,
It's not there.
not there, submitted, my lord. But
Any voters list of,
my lord, land documents contains entire family, my lord. Land documents, my lord, the Jamamandi copy. My lord, in
where is that document?
my lord, at page 38, translated copy, vernacular, lordship will find page 39 onwards, there is some wrong pagination, my lord, of the vernacular part. My lord, page 43 will be starting of the record, my lord. Page 43. There
43.
has been wrong pagination, my lord. Page 43, vernacular. I think my lordship can understand the Assamese also. That will be better translation and page 43, my lord.
Ha.
Father's name is at serial number 3. Then my lord, fourth,
Jalil.
Abdul Khalik is the paternal uncle who was examined. Then my lord, one is also paternal uncle, the elderly person. Abdul Sattar, they are also paternal uncle. Isab Ali also paternal uncle. Then my lord, proceeds name and our brother sisters are at page 42, serial number 17 to 24. My lord, petitioner's name is at page serial number 20. Mother's name is at serial number 25. That is also in record. In record, it is properly given, my lord. Hmm? In writ petition, we have committed mistake, my lord, annexing the, my lord, is order of mutation, my lord, in remarks column, page 43, order for
Not safe.
No, here also, please go with the order sheet first page of order sheet. And the first order sheet reference is made, last order is that the evidence is filed, correct?
Yes, Lordship.
And paucity of time, it could not be cross-examined. Next page,
Yes.
it's already 5 p.m. So therefore, next date is the cross-examination, right?
Lordship.
Now, please come to the impugned opinion, page 62. No, of the brief.
Yes, Lordship. It says about the expert opinion.
No.
Page
62.
62, Lordship.
Page 62, para 1, subparagraph. Apparently, in this case, none of the exhibits are properly marked by the OP for identification. Some of the exhibits are marked using paper slips stapled on due to their laminated condition. Correct?
Correct.
Now, please come to the exhibits at the bottom of the original documents. At the end, you see previous page, previous to this laminated page. You see the tribunal has signed it. Correct? Even
Yes.
exhibits before they have signed it.
Lordship.
The tribunal has signed it. Now come to this laminated document.
Yes, Lordship.
This is a state lead apparently of 44.
Yes.
Correct? The tribunal does not sign this. And I've shown you the order sheet. Next page also, the tribunal does not sign this document.
That they have signed in the photocopy notes.
No.
Photocopy is also exhibited, the original is also there.
No, you see, the original is before the tribunal.
Correct.
It can't be wished away. You sign a photocopy, but you don't sign the original one. And you write in the order sheet that the originals were
They've slipped, put in
sli-
slips
slip.
because of the lamination.
Now you see, and see, next page also document, this document is 1937,
Yes, Lord.
correct? Now please tell us, what is so bad about the conduct of the party to have this old document laminated? Now, if the tribunal does not sign it, it could have told the council, you go and purchase a marker and come and we'll sign it thereafter. And then you either you write in the order sheet so that the parties can come to tribunal and then rectify its mistake. Because all my original mark sheets, if I'm pointing out a finger here, 3 fingers are at me. I check my own documents. All my documents are laminated. Nobody advised me not to have the original documents laminated.
Ours also not laminated.
No, means I'm not on you.
And we also laminated because
But,
those are
but the
precious
tribunal
documents.
finds fault as it is laminated. Now, there must be some law which says that documents should not be laminated. And if there is a mistake of the lawyer in stapling it, the tribunal could have told that you go and purchase a marker, it will be not more than 15-20 rupees for a marker. Write it and sign it.
This document, the 37 document, they haven't signed at all. He hasn't signed at all. But other one, Lordship, the Xerox copy is there and the same exhibit has been marked.
No, but you see, he is writing that it is by using papers not properly. That is troubling us.
I agree, Lordship. That could have been avoided. Or he should have been more careful about this.
No, you write in the order sheet that I reject your document. It is laminated. The parties could have taken rectifiable
Because they could
steps
have taken this.
in a manner provided. But you see, the rejection of this document is only because of that.
My lord, exhibits are not proved on the basis of primary evidence that has been given, my lord.
Paragraph 5.
Paragraph 5.
It's not sustainable.
That's it.
Because Mr. Kalita, everybody is not fortunate to be able to purchase a land. Somebody has an ancestral land. He's holding on to that land. And therefore, how will the document be proved?
No, that's correct.
I'm
I have
asking
gone through
you-
it, Lordship. I found it little bit.
I'm asking you because I am afraid of ghosts. Should I invoke ghosts to come and prove document belonging to some of my ancestors? And we'll have to know a person who can call them.
So this is a primary evidence, Lordship. I mean, this is the original copy.
It has to be remanded back.
So this can be, I have gone through this, I have read this brief. Otherwise also that voter list also he's asking for certified copies also he's asking for proving. So, I mean,
That is also not correct, my lord.
there is
There
not,
are so many-
that is not correct position of law. That those are certified
Para 4,
copies.
my lord. Para 4 of
Those
the.
are
Yeah, we
certified
understand that,
copies.
but this non-marking of the document, we find it
Yes, Lordship.
acceptable. We had passed a judicial order requesting the Home Department to send some person here to watch the proceedings.
That has been communicated, Lordship. I mean,
Yeah.
that has been.
You see, the impression we are gathering is that some people are there just because of reward for declaring people as foreigner. Daniel, we'll pass orders in chambers.
My lord.
This matter.
My lord, we have another item, my lord, item 10. My lord, I may be excuse my lord, another date maybe. In item 10, my lord, I want to leave the court, my lord.
Okay. I thought you were going by the toss. One case you win, one case you lose. So therefore you don't want to lose today's matter. Okay. Item 10.
I should be, my lord, in a assemble in Chanmari, my lord, regarding Manipur violence, my lord. I am called by senior citizen like Hiren Gohai, Professor Mannan. So I should go there. I think to
Senior
accompany them.
citizens. Are you senior?
My lord,
Citizen, as a citizen,
Senior
you are
citizen.
senior. Okay. You look young.
now I am senior citizen, my lord.
Now you are senior. Okay. Acha. What's the representative of the prayer made by Mr. A.R. Sidha, counsel for the petitioner, matters to adjourned today, list after 2 weeks. Okay. This will pass in chambers, but this order, there'll be some delay. Either
Well,
tomorrow or day after tomorrow it will be
Well.
released.
Deep level, lord.
Mr. Sigdar, this, give us a judgment on that, what you call, in the manner of proof, have you brought any
Yes, my
judgment?
lord. Yes, we have judgment, my lord. We have given the list, my lord,
You're given a list
but
with your pen?
I want to give, I may give some one hard copy on set.
Please, please. Yes. It makes the work easier.
My lord, on AIR 1963 Supreme Court, M. Ramappa versus M. Buzappa. Then my lord, AIR 1983 Odisha and Mujibur Mian of our High Court, my lord. Only these three judgment is sufficient, my lord.
Okay. Just pass it on. We'll just
Well.
glance through it.
I've given the list, my lord. My lord, certified public documents, my lord, need not require to be provided. In Ramappa case, paragraph 9, my lord. Paragraph 9. Public documents. And in Odisha court, my lord, that is
just a-
paragraph 5A.
Just a moment. Just a moment.
5A and 7, Odisha court, my lord.
Just a moment. We are not yet over with 63. Mhm. It will. Marking करेंगे sir.
Paragraph 5A and 7. No, no, it would be a issue. And Mujibur Mian, my lord, it's very short judgment of our High Court. In the last paragraph, it has been mentioned. Last paragraph, Mujibur Mian. पूर्वी तक कौन से ना my lord, in para 4, Mujibur Mia. My
Item 5.
My lord, in this case, my lord, LBO report is totally blank, my lord. And moreover,
When we are examining on merit,
my lord, the WS file taking some players, WS is page 42, my lord.
where is the opinion? Which page is the opinion, Mr. Dey?
Opinion, my lord, at page 72, my lord. The relevant portion, my lord, page 74. My lord, in this case, my lord, learned court below call for a report from the police officer, SP, my lord, regarding his father's name, verification of his father's name, whether his father's name sometimes written as Abdul Rahman, sometimes said Abdul Rahman and Rukman Sheikh, whether this person is the same person or not. The landed court below, tribunal below has passed an order, my lord, to verify whether Jurad Ali is the son of that Abdul Rahman or not. And accordingly, my lord, police has, after inquiry, submitted a report. That report was not at all considered, my lord, by the tribunal below.
Which page is that report?
My lord, kindly see the order sheet, my lord, at page 4, and the LCR, my lord. Report is, my lord, this is the order, my lord, 31/3/2018, my lord. Order. Order dated 31/3/2018. And the report is as page 85.
Wait a minute. Report is at page?
85, my lord, LCR.
Seaman, one identical person.
If the report is considered, my lord, no case is there, my lord. Apart from this, my lord, petitioner's name appeared in the voter list of 1966, my lord.
Petitioner's, his own name.
Petitioner's name, yes.
Where is that document?
My lord, voter list, 1966, page, my lord, 24 of my read petition,
24.
24. In the record also, original papers are there, my lord, exhibited copies, my lord. Page 24, annexer P1.
What is your name?
My name is, my petitioner's name is Juran
Juran
Ali, my
Ali.
lord. Serial number 41,
Abdul Rahman.
Abdul Rahman.
In your written statement, where is your written statement?
Written statement, my lord, at page 42, my lord. And in paragraph 13, my lord, petitioner categorically stated his father's name differ from voter list here and there, my lord. The statement is given at paragraph 13, my lord. Page 45. My lord.
Relevant paragraph of the opinion.
Discrepancies of name, my lord, it is held in page 75, my lord, internal page 4 of the judgment. Your order, my lord. Second paragraph. Here in the above three exhibits, the name of Opie's father appear. Rahman Sheikh Abdul Rahman Rukman Sheikh Ghatu Mullah, the son of Ghatu Mullah, Ilyas Ghatu. Names appeared in the electoral roll are related to his father's name, but without other corroborative supporting evidence, how can we believe that the person concerned, as appeared in the exhibits, is the father of OP? The major discrepancy in the name of the OP's father, coupled with other material omissions and contradictions, would certainly raise doubt over our person concerned. OP is not disclosed his grandmother's name and totally silent about the Maitan Nessa Bibi, wife of
This 66 is exhibit 2.
my lord.
What is the discussion on exhibit 2?
Exhibit 2, 66. Duran Ali Abdul Rahman. 74.
Yep.
Exhibit 66. Exhibit 2, Electoral Roll 1966.
Mr. Kalita,
Not s-
this opinion at page 75, discarding exhibit 2, we don't find it sustainable. You see, in this case, the petitioner does not, independent of the fact that whether his father's name could be proved or not,
His name
his
appears.
own name appears in
His name
66.
Linkage
Therefore-
is not necessary, my lord, in this.
Then linkage is not necessary.
Not necessary.
The only thing is that, Lordship, since he has submitted these documents, if Lordship peruses other documents also,
No, no, you see, we don't have to go to any other document. Please come to page 53, 53.
5-3, yes, Lordship.
There's a cross examination.
Yes, Lordship.
Sixty-six voter list is not even doubted.
66 voter list, Lordship, only it was 66 voter list. Only thing is that like this is one Juran Ali,
And he is saying that I am there.
Now he's Juran Ali. His name is Abdul Rahman. Correct, Lordship. Now in 60 voter list, 66 voter list, 66, no, Lordship, 1 second. Yes, in another voter list of 1970, that his name is Duran Ali, but his father's name becomes Rukman Sheikh. So there is a doubt created whether these two persons are
That's why
same.
we're looking at page 53.
Yes,
Where is the
53
doubt?
absent. 53, he is saying that my father died 1 or 2 years ago to 1970. That's why he is saying that his father's name and his name did not come together. That was his reason of saying that. So he died in so and so. My mother's name is Zubeda Khatun. My mother died before 1970. My father was in village Bokuamari. I was born in the said village. My father Abdul Rahman and uncle Subed Ali were expired. My grandfather's name is Ghato. I have only one daughter so and so, name so and so. I went to village Baladmari under Fakirganj police station, few years in the middle of so and so. So this basically says that like he is Abdul Jalil. He is Jalil Ali, sorry, Zuran Ali.
No, no, in the cross, you see, this is, you have a AGP to represent the state.
Yes.
Therefore, this is an adversarial litigation.
Correct, Lordship.
So far as you are concerned, it's an adversarial litigation. The state does not even doubt the correctness of these four names of his father. So no questions is asked that they are not same. They are not even a suggestion is given that these four people are different. Now you forget his father's name, maybe XYZ. He comes and deposes that 66, this is my voters list. Even that is not questioned that you are not this voter.
Keeping that apart, Lordship, otherwise from other documents, I mean, that Lordship may kindly,
No, no, but this is more damaging. Look at this record. We'll take a break and come back. We have flagged it.
Lordship,
Last page, the last side is the document
okay.
where the tribunal passes an order, asks for an inquiry, that inquiry report is there. Now
That
the
that is
SP
annexed in the,
now you can see the original one. The SP now says that he is the citizen of India.
Citizen of
that,
Yes.
I've seen that, Lordship.
Now,
That,
now you see,
I mean, Lordship, this has come from the SI and SPS forwarded, they just like that.
no. You see, but the difficulty is every morning I try to shake my head, but the civil procedure code does not go away from it. Correct.
That will never go, Lordship.
So once authority who's asked to report makes a report, that becomes an evidence. You can't just wish it away. Order 26 to 10(2). You just can't wish it away. The reason is paragraph 4 of the Tribunal's Order 1964. It says that the tribunal exercises jurisdiction, it's a civil court for the purpose of inquiry and
Inquiry.
inspection and the discovery. If these three are covered, then you can't shake away. Even
that
if I
cannot
shake my
be
head, then orders
Only
26
thing
to
is that, like declaring somebody's.
go away. We'll take a break and come back. Look at that
Lords.
document. Senior citizens and terminate.
Acceptable. So only one small thing, Lordship, I'll just point out. So Lordship, he has to prove that he was there prior to 1970. This Juran Ali, whoever the father is, like that will be covered. Now Lordship, 1966 voter list, Lordship will find that his name is Juran Ali, son of Abdul Rahman. Abdul Rahman. Then Lordship will find in 70 voter list at page 27, your Lordship. The father is Juran Ali, his name is Juran Ali and Rukman Sheikh.
Can you come to this page 44?
44.
This is a part of written statement.
Yes, Lordship.
Paragraph 8.
Yes, erosion, yes, Lordship, yes.
No,
That I have
this
seen, Lordship.
97, 98, and it again comes from paragraph 7 also. Previous page.
Correct.
He gives a description of 1970. What was his name? So and so, which house?
So here,
Then
Lordship,
8 is the erosion.
yes, Lordship.
So there's numbering is wrong. Another 8. He gives that number, son of A. Rahman, and all these things.
The only thing, Lordship, I
And
just,
then paragraph
thought I
11, he
missed.
says son of Abdul Rahman.
yes.
So this is there, and
Oh, yes.
therefore in the
Only thing, Lordship, like I would like to point out the verification report which has been given, the verification report, Lordship will find the last paragraph only, Lordship, I'll just read out.
Yes.
So the verification record report should be that Juran Ali of 1966 and 70. And the Juran Ali whose name appeared in the subsequent voter list are the same person. He is the same person. Now here Lordship will find in the report, after completion of verification period, I have found as per produced documents that OP is Juran Ali, son of Rukman Ali. Now Rukman Ali,
Mr. Kalita.
Lordship,
See-
Lordship can Lordship.
No. You see, you are reading from that paragraph. Please come to the previous paragraph.
That erosion,
Description of document. No, page 60.
60, yes,
You are
yes.
at page 60.
Voter list, yes, Lordship.
Yes, so voters list of 1966, 60, 97, 71, 85, 2005, 2008, 2017, 1970. Self and fathers.
Yes, Lordship. Lordship, it can be remanded so that like proper appreciation can be done by the tribunal.
Because
Other than
that is why with this, no cross-examination.
that I agree, Lordship. Let it be properly appreciated there only, Lordship, rather than here.
Heard. Mr. PC Day. Learned counsel for the petitioner. Also heard CGC was there, Miss B. Sharma. Miss R. Devi Lanet, CGC for respond number 1. Mr. A. Kalita Lanet, standing counsel for the FT matters, representing respondent number 2, 3, and 6. And Mr. P. Sharma Lanet, additional senior government advocate appearing for respondent number 4. And Mr. H. Kuli on behalf of Mr. A. Ali, standing counsel for the respondent number 5. Mr. H. Kuli, learned counsel. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 13/8/2018, passed by the learned member, Foreigners Tribunal.
Dhubri.
No,
Foreigners
it's
Tribunal
Roman
2.
2. Tribunal
Two
within
Dhubri.
bracket Roman 2. No, don't write Roman 2. Second, 2 ND. Foreigners Tribunal, second, Dhubri. Mr. Kalita,
Lordship.
in that certified copy, page 72, at the top, it is written Tribunal Roman 2. Correct?
72, yes.
72. Now, in the signature at page 76, seal is second. So I am writing this second.
Lordship.
You're not writing Roman 2.
Lordship.
Okay. In case number FT, in FT case number 564/F/15, bearing police reference case number 296/98, by which the petitioner was declared to be a foreigner of post 25/3/1971 stream. Next paragraph. At the outset, the learned standing counsel for the FT Matters has submitted that from the various voter lists exhibited by the petitioner for the year 1960, 1966 or 1970, or 1985 or 1997 or 2005, 2008 or 2017, the name of the father of the petitioner is constantly changing, and his father's aliases are projected to be Rahman Ali, Rahman Sheikh SK, Abdul ABDUR Rahman, alias Abdul 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 Rahman, alias A full stop Rahman. Full stop. Accordingly, it is submitted that the petitioner was required to prove that the petitioner, namely, Juran Ali, Juran Ali, whose name appears in the voters list of 1966 and 1970 is the same person who's is the same person, which is unbelievable as the father's name are different. So accordingly, it is submitted that as the petitioner has failed to establish his linkage with his father, the opinion of the learned tribunal warrants no interference. Next paragraph. The records as called for has been received. Full stop. We have examined the records. Full stop. It is seen that in the written statement filed by the petitioner, the petitioner has, which page is your written statement?
Page 42, my lord.
The petitioner has given the details of the names appearing in the his and his father's name appearing in the voters list. As well as other names appearing in the said voters list of 1966. Similarly, the names of the family members appearing in the voters list of 1970 is also spelled out. Clarifying that his parent and elder brother had died, and therefore the names do not appear in the voters list of 1970. Similarly, the description of the family members whose name appear in the voters list of 1985, 1997, etc. are also given. Full stop. The written statement contains the different names of his father. Full stop. A similar assertion is found to be made in the affidavit in opposition, evidence on affidavit filed by the petitioner in support of his case. Full stop. Along with the evidence on affidavit the petitioner has exhibited the following documents. Certified copy of electoral roll of 1960 within bracket exhibit 1 ext 1. Next, this will continue. Certified copy this one. Next is certified copy of 1966 exhibit 2, 1970 exhibit 3, 85 exhibit 4, 1997 exhibit 5, 2005 exhibit 6, 2008 exhibit 7, 2017 exhibit 8. This you will find in page 73. Full stop. The records also reveal you can say it may be pertinent to state here that the petitioner was cross-examined records reveal that on 29/6/2018, the petitioner is DW1 and along with DW2, namely Samsul SAM SUL HUQE, was stated to be the neighbor of the petitioner. It is not that there is no cross-examination with regard to the existence of the petitioner in the name of the petitioner in the voters list of 1966 or regarding the various aliases of his projected father. Next paragraph. We also take note of the next paragraph. We also take note of the fact that on 31/3/2018, the petitioner has filed petition number 2144, by which a prayer was made to call for the police verification report as regards the actual name, identity and address of the petitioner and his father. And the no, full stop. On the strength of the said petition, now, on such petition, the learned member, Foreigners Tribunal Second Dhubri, had passed an order dated 31/3/2018, call for a police verification report to ascertain whether the petitioner, namely Juran Juran Ali, son of Rokman Rokman Ali of village Baladmara Baladmara, PS Fakirganj, and Juran Juran Ali, son of Rahman Ali Rahman Ali, alias Rahman Sheikh SK, alias Abdul ABDUR Abdul Rahman, alias Abdul 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 Rahman, alias A Rahman of village Bhalukmari BHALUKMARI, PS Fakirganj, is one and the same identical person as claimed. With a further direction to the Superintendent of Police, within bracket border, bracket close Dhubri, to appoint a competent inquiry officer, within bracket EO for short, bracket closed. Full stop. Next paragraph. So on the next date fixed, i.e. 27/4/2018, the police report was received by the learned tribunal. Full stop. The said report is available at page 85 of the records of the tribunal. Full stop. The ASI of police of Fakirganj PS had submitted a report, and after referring to the then certified copy of the electoral roll, copy of EPIC electoral roll of 1997, legacy data of NRC 1951, and electoral roll of 2018, as well as a copy of court affidavit, arrived at a conclusion that Juran, Juran Ali, son of Lokman Ali, you can copy it from there, same thing. So and so to so and so at in Fakirganj district, Dhubri, Assam, inverted comma closed, are no, don't close inverted comma now, are same and are one and same identical person. For the record, comma further recording that he has found Juran, Juran Ali, alias Juran Sheikh SK, are the same and one identical person, and he's Indian citizen as per documents. Full stop. The said report was forwarded by the officer in charge of Fakirganj police station on 27/4/2018. This report by the ESI of police is dated 27/4/2018. The same date was forwarded, and report was returned. Full stop. Next paragraph. Next paragraph. In the impugned opinion, although the police report was received and recorded in the order sheet of 27/4/2018, there is no discussion by the learned tribunal on the said report. Next paragraph. The procedure for obtaining such report is found to be covered under paragraph 4 of the Foreigners within bracket Tribunals bracket closed order 1964, which provides for requiring discovery and production of any document stop. Therefore, the court is of the considered opinion that as a report has been called for, the learned tribunal is required to deal with the said report. Next paragraph. Moreover, in the present case in hand, it is the case of the petitioner that his own name appears in the voters list of 1966, which is a document purportedly creating an entry of the petitioner in the state of Assam prior to 25/4/1971. Full stop. Therefore, irrespective of whether whether the petitioner has been able to prove prove that various aliases of his father irrespective of whether the various aliases of the father could be proved, comma, but his own entry in the voters list, entry of his own name in the voters list of 1966 is required to be independently dealt with. In light of the police verification report. Next paragraph. Irrespective of the fact that the police verification report is received, comma, but the court finds that the said police verification report has come on board on the strength of a petition filed by the petitioner, and therefore, in the opinion of the court, the petitioner has a duty to petitioner has a right to be granted an opportunity to prove the said police verification report. As the inquiry ordered by the tribunal was not in its own motion, but the same was on the strength of petition filed by the petitioner. Next paragraph. Therefore, comma, the court is of the considered opinion that an opportunity be granted to that this is a fit case where the learned tribunal ought to have granted the petitioner an opportunity of proving the police verification report. Dated 27/4/2018. Next paragraph. In view of above, comma, court is of the considered opinion that this is a fit and proper case for interfering with the impugned opinion dated 13/8/2018, passed by the learned member so and so in so and so. This is page page 72. Full stop. Result, next paragraph. Resultantly, comma, the matter is remanded back to the learned member, comma, foreigners tribunal, second Dhubri, for giving an opportunity to the petitioner to prove the police verification report. And thereafter pass a fresh opinion in accordance with law. Next paragraph. In the interest of expeditious determination by the learned tribunal and to compel the petitioner to appear before the said learned tribunal, comma, the court is inclined to provide as follows. Number one, that the petitioner shall appear before the Superintendent of Police within bracket border, bracket close Dhubri, within 10 days from the date of the order and shall furnish bail bond of rupees 5,000 with one surety of like amount to the satisfaction of the said authority. Next para. The petitioner shall appear before the learned member, comma, Foreigners Tribunal, second Dhubri, on or before 8/1/2024, and by producing a certified copy of this order, comma, await for further directions from the said learned tribunal. Next para. The learned tribunal shall thereafter hear the shall grant a reasonable opportunity to the petitioner to prove the said police verification report and thereafter pass a fresh opinion in accordance with law. We've given you time, 10 days to take bail and to appear before
My lord,
the tribunal.
if 15 days is allowed, because my client, with my client, is communication gap, my lord, I have to communicate with him 15 days. my lord.
Okay, 15 days. Make it 15 days. Okay. Just say one thing. Before this condition, sir, according to the impugned opinion, that is is set aside and the matter is remanded back. Just see that I forgot matter is remanded back. Before that, I have to set aside the order. Just check up. So, and last night, let the records be sent back. We'll resume post lunch.
Yes.
Wait, please, Your Lordship.
Last time you referred to two situations. Number one, 3/8/2012. He was facing the interview for voluntary retirement.
My lord, yes.
And on 14/8/2012,
My lord.
he was irritated and at 16 hours, he fired 2 rounds.
My lord.
You were there.
My lord. Now my only, my lord, point is that, my lord, it is no way I am, my lord, negated that I have not did the said occurrence. My lord. I did it. But, my lord, I was in technical point, my lord, for conversion only. My lord. They have, my lord,
304
imprisoned me
part
for
2.
302. I want to convert, my lord, 304 part 1.
Okay. Okay.
For which, my lord, there is no, my lord, previous enmity is there, my lord.
But
The intention part is absent.
even for that, there must be some evidence led that
My lord.
it was a grave and sudden provocation.
My lord, yes.
How do you establish that?
Yes, my lord, that's why, my lord, I like to place, my lord, the PW 17, my lord. What he still in, my lord.
Just a moment. PW 17.
My lord, yes, PW 17, my lord, at page 147D of the my lord petitions. My lord.
127 B for Bombay.
D for my lord,
Delhi.
my lord, yes. 147D.
D. Yes.
Lordship, that those were the evidences I have xerox from the original. So Lordship may.
Okay. Okay. Thank you.
And before that, my lord, I would like to place, my lord, the last occasion the question was raised regarding the Insas rifle. I have got some note, my lord, regarding the Insas rifle. There has, my lord, 3 modes of fire, my lord. Question.
No, I got the technical report. They
My-
say that the information received by me, subject to what you say, is that it has the mode of automatic, and then it can be turned off to single shot also.
My lord, yes.
And they say that there are experts who are so accustomed to use this Insas or any other AK-46 or other rifles that they can control their trigger,
My,
and they can, even in the automatic mode, they can shoot 1 or 2.
my lord, yes.
So it depends on the and the practice they have
My lord.
to that effect. And what you call the shot accuracy in the automatic rifle is a bit less. There has to be a random firing.
My lord.
This is the accuracy is lower than the normal rifle where you have to aim and shoot. These automatics are normally not used for aiming and shooting,
My
and
lord.
therefore there is a
It's random, my lord.
at random, or it may not be so accurate.
My lord.
So therefore, it's a burst of fire which really triggers the actual offense. That
Right.
is what.
And
was
thereafter, my
informed.
lord, the PM autopsy report, it is found that, my lord, 2 injuries found in, my lord, one of the deceased and 2 injuries found in one of the deceased.
So this
But others,
tallies,
my lord, goes my lord blanks.
no, but that tallies with the information I received that it is a spurt of fire. So therefore, when you are firing it and you are pulling the trigger, pressing the trigger,
Right.
rather, then there's an automatic shot and therefore there is no control over it.
My lord. That's why, my lord, the person who known to him, my lord, he was also dying.
Yeah.
He is standing behind the, my lord, the main deceased, my lord. That's why I'm saying, my lord, this is not an intention to kill the both the persons. The second one is there is clearly, my lord, shows, my lord, there is no intention because he not known to him, my lord, that other persons. My lord.
PW 17.
147D, my lord. Page number.
Yes.
It start from, my lord, 3rd para. It's highlighted, my lord. The court also believed the testimony of Constable Armor Partho Sarthi Ghosh, PW 17, my lord. That on 14th August 2012, at about 18:15 hours, the duty SO and duty NCO produced 6 Insas rifle and 1 carbine machine for inspections. On inspection, he found the rifle being butt number 81 and body number so-and-so was having gas fouling in barrel, piston and cylinder. No gas fouling was noticed on the rest of the weapon, suggesting that fire was carried out only from the Insas rifle bearing butt number 81 and body number so-and-so. The court found that the accused also admitted this issue in his statement given UR 93 of BSF rule. The accused stated that on 14th August 2012, he was detailed as a guard commander of the guard party of a Tentage store. He collected his personal weapons, 5.56 Insas rifle bearing butt number 81 and body number so-and-so, and 2 magazines from the court at around 17:25 hours. And after that, he went to the unit magazines and collected 40 rounds at around 17:30 hour. Since it was a drizzling at the time, the accused stood in the morcha for a while. No sooner did the drizzling stop Then he left the magazine complex for the evening roll call towards GD. However, as he was climbing down the step stair and was about to reach the road, it began to drizzling again, which led him to realize that he had left the umbrella at the magazine. Therefore, he turned back and set out the magazine to collect his umbrella. On reaching the magazine morcha, he saw Constable Sagir Alam, the deceased, and Constable Varadigari Chandra Naidu were seen sitting close to each other and filling their magazines on the veranda of the magazines. They are also collecting the arms and ammunition and filling the magazines. While he was searching for his umbrella, Constable Sagir Alam, who was filling the magazines and mocking, said that following words to the accused, हे मकरा मोटू मेजर तुम और 10 मेजर छुट्टी के दौरान अपनी सोएंसो नहीं करता होगा और ही कोई करता होगा and after saying this he spit at the accused, my lord. This is the main reason, my lord, why he my lord the shot upon the Sagir Alam, my lord. This word by Constable Sagir Alam, who was more than 20 years junior, involving purely personal matter between the accused and his wife, was so insulting and difficult to digest that the accused felt humiliated and hurt. His self-respect was taken. It suddenly provoked him up to such an extent that he lost his self-control of his sense, which he led him to immediately cock his rifle, then an open fire on this Sagir Alam. And this is, my lord, the main whole gamut of the case, my lord. So, my lord, from this issue, it is found that, my lord, there is no premeditation, my lord. There is no any intentions, my lord, to kill these two persons, my lord. And moreover, my lord, we have to see, my lord, they are sharing, my lord, same room, for living in the same room, both the, my lord, the deceased and the accused. There is no previous enmity. There is no any intentions. And there is no any motive. Motive is also absent in this case, my lord, to kill him. And immediately after killing the, say, two persons, my lord, he tried to kill himself also, my lord. But somehow he, my lord, saved, my lord. At this issue, it is not under dispute that the accused admitted the issue. Hence, in the light of the available evidence, court take this issue, death of so-and-so, and death of so-and-so is firing shots from, and my lord, the time see, when he collected the ammunitions at around, my lord, 5 p.m., my lord. And immediately after the offense, and they also, my lord, collected the arms and ammunitions. They are also in duty. From the original records, it shows, my lord, is PW 15, my lord. PW 15, my lord.
Parthasarathi.
That's why PW 17 is a doctor.
Yes,
My lord,
doctor.
yes.
PW 17 is the doctor.
PW
15, my lord. He is the
He is
PW
15.
15 in the original records. And one more witness, Your Lordship, PW 10. Very Jitender Patil. এখন দিছিল।
In this,
Accused statement of the- That is on portion of the accused. At 159 not assuming
is it page 160?
159 and 160. Question of the to the accused 160, Your Lordship, yes.
60.
Do you wish to call any witness in your defense?
No, but where is the 147D?
My lord,
You have read this last paragraph.
my lord.
Where is where from where this finding has come? The court found that the accused
147
D
D, my lord, yes. The court also believed,
Found.
the court found that the accused also admitted this
but
issue
where
in
is where is
statement
this?
under rule 93 of the BSF rules, my lord.
Where is this?
Admission to court. He admitted in 164 statement, my lord, before the magistrate, my lord. That is at page at page 40, my lord. My lord, no, my lord, only confession statement is there, page 40, my lord. Page 40, my lord, annexure 8. This is before the magistrate, my lord, what he confessed, my lord. Got it, Your Lordship? My lord.
It is extracted from page 43 onwards.
Page 41 is written statement. 41 is the written statement of the present petitioner, the accused, where he stated everything before the page 41, annexure 9 you will also. After confessional statement. The confessional statement is at page 40,
40.
40. Annexure 8 euros. That is exhibit 65.
So you see, this this page 41 is the written statement.
My lord,
The part which you read at 147D
my lord,
is extracted from here, specifically page 43 onwards.
my lord.
Correct. After correcting the emanations, I went to the Morcha of magazine.
Hmm.
This, the next para 12, 13,
My lord,
and this 14.
14.
This is what is there.
My lord, yes.
Correct. And then
Exactly.
15, he says that he was humiliated and therefore he lost self-control.
My lord,
This is a part of written statement.
my lord.
To rely on a written statement for the purpose of that explanation
My lord.
would be difficult in the absence of either a statement under 164 or the evidence of the accused himself.
My lord.
Because a written statement, how far it can be accepted for the purpose of conversion of 302 to 304 part.
Yes, my lord. That's
two.
why I'm saying, my lord, the PW10, the one of the constable, my lord, of the Said Barak, his statement is also there, my lord.
PW10.
PW10 at page 94 of the, my lord, list of witness, my lord, bunch. Page 94, my lord.
Just a moment. Page number?
Page number 94 of the, my lord, yes, that bunch. List of witness bunch. Jitender Patil. Married to
Yeah, I've completed page 1. Just read it. My esteemed sister will.
my lord.
Yes, please read it.
PW 10, my lord. The constable Jitender Patil. Headquarters also, I'm skipping this, my lord. He joined in service. That part also skipping, my lord. Yes, from page 95, my lord.
Yes.
In the month of July, Constable Thupe Subhas had come to headquarters BSF Karimganj as an attendant to a patient of 111 Battalion BSF who was admitted in SHO headquarters hospitals and stayed for about 15 days. During this period, we met each other for about 2-3 times, and wherever we met, he had consumed liquor, and at the same time, he appeared to be happy and did not tell me about any problem. On 14th August 2012, at about 17:15 hours, and got a phone calls from Constable Thupe Subhas before the incident, madam, from his call number so-and-so, and spoke to me for about 3 to 4 minutes. And he asked about my well-being. Then he told me that he is mentally disturbed, and when I asked the reason, he told me that he had a fight with someone in his unit and also has an apprehend that they might catch him, and told him to go to the constable Vidyadhar Kulkarni, who was also posted for 13 Battalion BSF, 111 Battalion BSF. Initially, he agreed and then again asked me what to do in case of if they came to catch him. They and told him to go to his office in the unit for help. Further, he told me that these people are saying I am affected with AIDS. Then I told him how they could say since they are not doctors and either to go to the best doctor to get checked for AIDS or proceed on leave to get the roughly checkup, and he agreed. He again told me that he will do something to himself. I advised him not to do such things and again told him to speak to Constable Vidyacharya Kulkarni so that his problem can be solved. Then he asked me to inform any of his family. I told him that I don't have their mobile number. Then he told me that he will do it himself and disconnected the phone. The next day I came to know Constable GD had that Constable Thupe Subhas had shot dead two constable of 111 Battalion BSF. He has suffered bullet injury. I was asked by the 21 so-and-so BSF whether Thupe Subhas had spoken to me on 14 August 2012, in which, and I said yes, and narrated the whole conversation between me and Constable Thupe Subhas. It's come to the GD and he took me the mobile and returned me after 1 hour. From his statement, it is, my lord, very clear that at the same time before the incident, he talked with these persons, this constable, and he asked his about well-being. And thereafter, he said he was mentally disturbed he was disturbed by someone else. And immediate after the cut off his phone, he did the incident, my lord. And other one more, my lord, the PW, that is PW 14. PW 14 at page at page 119, my lord.
Just a moment, a passing thought came to
My lord,
the mind, and therefore I'm asking you.
my lord.
You see, on 14th, he, this accused confides something to the PW 10
My lord.
and expresses that he is agitated. And then after he says that, okay, he will tackle it. And after some time, he goes and shoots. Now, between that period, there's again an incident where he was rebuked by the same person. Correct? Now, can this be looked into in a manner that he's going and having a conversation with these people,
My lord.
with sorry, with the main person who has died? I forgot the name.
Sagir Alam.
He died. So therefore, can it be read to be a premeditated attempt?
My lord, premeditated attempt could be, my lord, it should be, my lord, continue for last many days, my lord. So, my lord, from his conduct, it is seen that, my lord, there is no enmity, no motive, no any intentions, my lord. Because if there is a motive, my lord, the motive part is completely absent in this case, my lord. So, my lord, it is his duty. He collected the arms and ammunitions. He went for it, go for his, my lord, parade's duty, my lord. The counting was there, my lord. He was counted. He again Well, this is also my lord collecting the magazine. They were ready for the duty. But immediately when he collected his umbrella, when he forgot, at that point of time, my lord, he was abused. He was teased. Then only, my lord, he lost his control, he fired upon him.
Okay.
If there are my lord, premeditation, then my lord, he can tried many occasions. And thereafter, my lord, Lordship may see, he tried to kill himself also, my lord, after doing, because he completely lost his control, my lord. He didn't run away from the place also, my lord. If he doing this thing, my lord, he immediately ran away from the place of the occurrence, but he didn't. He killed himself, my lord, tried to kill himself, my lord. Because he didn't know, my lord, what he doing at this moment. If there is premeditation, my lord, he cannot be killed himself, my lord. He ran away from this place of occurrence after doing the incident, my lord. And PW 14 also, my lord, it's a very long, my lord, the statement, the positions made by the PW 14 at page 119, my lord. Start from page 119, my lord, the list of witness, my lord. And the relevant para I am reading, my lord, from page 129. From second para, my lord. Got it, lordships? Page 129, the relevant para, my lord, of PW 14. Start from second para, my lord. On 14th August 2012, at about 17:45 hours, he collected 40 rounds of INSAS ammunitions and INSAS rifle for the for performing night guard at unit for unit welfare center. While loading the bullets in the magazine, Constable Sagir Alam causes there and call him AIDS Wala. He became very angry, but managed to control his temper. Initially, my lord, he managed to control his temper. Since he forgot to take his umbrella near the magazine veranda, while returning there to collect the same, Constable Sagir Alam shouted at him by calling him Makra. At this moment, he got so wild and could not control his temper and started firing indiscriminately towards constables Sagir Alam from his service INSAS rifle. In the process, Constable Sagir Alam and Constable Varadigiri Chenraidu were seriously injured. After inflicting serious injury to the two constables, he himself from his service rifle issued to him, where he became unconscious and fell down on the ground. Beyond this, he knew nothing this all about it. He is also, my lord, one of the immediate witness of the said incident, my lord. And he saw, my lord, before the incident, what initially he controlled his temper. On next occasion, when he again teased him, my lord, abused him, he, my lord, lost his control. And my lord, he fired upon the deceased. And one more thing I have pointed before your lordships, that his conduct, there is in, my lord, initially an inquiry was conducted. What they have found, my lord, that is at page, only relevant para I have written, my lord. Yes. that is of the finding of the staff court of inquiry. Before discipline proceedings, my lord, a court inquiry was conducted. And what they have found, my lord, during court inquiry, my lord, that is at page 7 of my petitions, my lord. I have extracted the relevant, my lord, witnesses, what they have saying against the accused petitioners, my lord, of my petitions, my lord, at page 7, my lord. Page 7 of my petitions, my lord. What is your lordships? And paragraph 16. These are the, my lord, I have prepared a table, my lord, where we have extract the findings of the witnesses. That was findings by the staff court of inquiry, my lord. Finding number 4, my lord. Finding of the SOI, that paragraph 16. We are directly reading from the table, my lord. Constable number GD Khargo Sema, Khekahot Sema of headquarters copy performed the duties of the BSM. There were no reports of any misbehavior, any complaint by CT Thube Subhas against any other personnel of the COI. That is witness number 15. His statement is that, my lord, his conduct, my lord, he's a very well behaved person. And witness number 18, that is point number 4, Sri Thupe so-and-so, Mayor so-and-so, Poppy was performing the duty of adjacent as per the unit record. CT Thube Subha is having a clean record of service and no one ever complained about his misbehavior or by any other constable against him before this incident. That is witness number 18. And my lord, the point number 10, at no point of time he came up with his problem or grievance with his colleague or seniors. He had never approached personally to his superior for any grievance. Constable Thupe Subhas used to remain quiet and hardly mix up with others as he was a newly posted having less acquaintance. CT Thupe Subhas was interviewed on 3rd August 2012 by the Commandant 111 BSF as he wanted to proceed on voluntary retirement since his wife always remained sick after an operation in 1995 and he has only shown as such he wanted to proceed on voluntary retirement to look after them. His plea was accepted and due date of retirement was fixed on 31st December 2012. That was explained by witness number 1, 17, 18 and 20. From my lord, his behaviors, his conduct, his past record reveals this, my lord. He has no such enmity with any one of them, my lord. And his wife was sick, because of which he was granted for VRS, and that VRS was also granted by the department. And point number 14, my lord. Thereafter, he went back to collect his umbrella, which was kept outside the veranda. He saw Constable Sagir Aram filling magazines and kneeling position in the veranda, who comment quotes that is Makra Admi idhar kya kar raha hai, unquoted. By this comment number, Constable Thupe Subhas got irritated and fired 2 rounds from his personal weapons towards Constable Sagir Alam from a distance of 4-5 feet, followed by 3-4 bursts fired at about, there it shows, my lord, 3-4 bursts. 3-4 bursts fired at about 17:45 hours. Thereafter, he moved to nearby corner outside the veranda and fired at himself by keeping barrel on a rifle on his left chest and pressing the trigger with his right arm. That is witness number 1, 2, 4, 7, 8 and 10. They, my lord, made a depositions before the court of inquiry, my lord. From all, my lord, the evidence which was placed before the court of inquiry and the, my lord, before the court, it was found that, my lord, there is no any, my lord, premeditated, my lord, intention is there, my lord, to kill the said deceased. And there is no any such motive is there. Motive is also absence and intention is also absent. And there is some provocation is there. Because of these provocations, my lord, he fired upon them. And my lord, the second person who died, my lord, he known to him, my lord. There is no, my lord, conversation, nothing. He is just standing behind the Sagar Alam. That's why he died, my lord. That was my humble prayer before this honorable court to conversion the matter in 304 part 1. I am not asking for 30 part 2 also, my, because he was killed by the arms and ammunitions was used. That's why I'm not asking for part 2. It is a, my lord, no doubt, my lord, 2 life has gone, my lord. 2 family has been, my lord, destroyed. So may I pray, my lord, he is now he is for 12 years, my lord, in jail. Since 2012, he is in jail till date, my lord. So it is converted to 304 part 1, my lord. And moreover, my lord, if your lordship may allow, I would, my lord, place one judgments regarding the same issue, my lord, where also, my lord, he fired by a gun, my lord, to children's, my lord, but Supreme Court has converted into, my lord, 304 part 1, 2, my lord. Some children, sirs, my lord, tried to pluck fruits from his garden, my lord. He is a retired person, but he shot the, my lord, one of the children, my lord, he died. But later on, my lord, Supreme Court, it's converted to 304 part 2, my lord. That is, may I allow to read, my lord, from the paragraph 2, my lord. May I read your lordships? The case of the prosecution in brief is that the appellant herein was a retired lieutenant colonel in the Indian Army. After his retirement in April 2011, he was permitted to live in the staff quarter in the defense compound for a period of 3 months. The army man enclave abounds with a fruit-bearing trees, which attracts ursines who live in a apartments across the road, particularly boys aged about 10-15 years who crosses the compound wall to pick almonds and mangoes. At about 1:30 p.m. on 3/7/2011, the deceased Dilshan and 3 of his friends, Sanjay, PW2, Parvin, PW3, and Vignesh, PW7, ventured into the army men enclave to pluck almonds and mangoes. While they were filling stone at their target, they suddenly heard a massive sound, following which Diljan, the deceased, fell down on the ground. PW2, PW3, PW7 ran away from the scene. It is further the case of the prosecution that it was the appellant herein who had shot the deceased with a pistol, consequent to which the deceased sustained bullet injury on his person and died. The distance between the appellant and the deceased was about 100 meters. It is clear from the evidence that it was a usual for the boys residing in the adjoining colony to enter the prohibited defense area to pluck fruits. It is also not a dispute that the appellant was residing in accommodations provided by the army for a period for 3 months after his retirement. It is also clear that the appellant shot the deceased while he was attempting to pluck fruits from the defense enclave. The only question is whether the appellant intend to murder the deceased or not. As brought out in the evidence of PW5, Jaya, a domestic help working at the appellant house, the appellant was a short-tempered person and used to chase the boys who used to jump into the defense compound to pick almonds. On one occasion, the boys had even damaged the windshield of the appellant's car. Having persuaded the evidence on records carefully and with due regard the temperament of the appellant during his frequent runnings with the children, we are of the opinion that the appellant committed the offense in question whilst he was deprived of his power of self-control upon the sudden provocation by the children. Here my case is also, my lord, same. Here also, my lord, he lost his self-control due to his provocations, my lord, this Sagirala. And in our consideration opinion, there was no calculated intention or premeditations on his part to commit the murder of the deceased. Hence, the offense committed by the appellant may fall under the first exception of 300 of the IPC. Consequently, it can be safely said that the appellant has committed the offense under 304 part 2 of the IPC. That is quite, my lord, identical with my cases, my lord.
Yes.
And one more judgment, my lord, it is not fired by gun, my lord, but the ratio of the say judgment I have to place, my lord. That is also converted to 304 part 1, my lord. Here is also one family disputes quarrel between the, my lord, fathers, daughters, and mothers, my lord. That is paragraph 12 and 13, my lord. Paragraph 12 and 13. My lord, paragraph 12, my lord. It is not in dispute that the relation between the deceased on one hand and the other member of the family consisting of the appellant wife of the deceased, his son, the original accused, and Priyanka PW1, daughter of the deceased, on the other hand, were not cordial. Their relationship was not cordial. If the testimony of PW1 is read as a whole, it would be revealed that her father and mother often quarreled. PW1 in her evidence has stated that the deceased Mastram fractured the leg of her mother during one of his such quarrel, and a criminal case was also pending against him for the said offense. Her testimony which shows that her father was residing separately in old house, whereas the 3 other members were residing separately. It is stated that on the date of the incident, she got up at about 7 o'clock in the morning and asked her father to give 500 as she wanted to take part in a NCC camp. Her father refused to provide the said amount. PW1 narrated the said incident to her mother. Her mother asked her father to give the said amount to her. Even then, the father did not provide the said amount. Thereafter, a quarrel started between her father and mother. Her mother gave blow with a stick on the head and legs of her father. Her father sustained injury, which led to his death. It is to be noted that the weapons used by the crime is stick, which was lying in the house and which by no means can be called as a deadly weapon. Therefore, the possibility of the appellant causing the death of the deceased while being deprived of the power of self-control. Here is also, my lord, question of the depriving of the self-control. In my case also, my lord, no doubt, in that case, the stick was used. In my case, the gun was used. But here is also, my lord, due to deprive the power of self-control due to the provocations on account of the deceased not agreeing to pay the and could not be ruled out. Here also provocation is there, my lord. In my cases also, my lord, provocation is there. And one more judgment, my lord, Nawaz, that is, my lord, reported in 2019, my lord, of Supreme Court passes an order, my lord. That was the division. This is also a case of, my lord, the sudden provocations and which was converted to 304 part 1, my lord. That para 12, 13 and 14. In this case, my lord, paragraph 12, 13 and 14, my lord. Yes, my lord. The paragraph 12, my lord. Materials on record also reveal that the accused number 1 tried to hide the offense for about 40 days by giving false explanations about whereabouts of her husband. Be that as it may, on going thorough the extrajudicial confessions carefully, we find that the case may be fall under the 304 part 1 of the IPC, in as much as the offense may fall under the exception 1 of the 300. Immediately after hearing the deceased calling the accused number 1 and her daughter as prostitutes, the accused number 2 suddenly slapped the cheek of the deceased. Immediately after receiving the said assault, the deceased fell down unconsciously and thereafter he saw throttled to death. Everything has occurred in a fractions of a minute. Since the accused, because of the aforesaid conduct of the deceased, calling accused number 1 and daughter as a prostitute, as deprived of the power of self-control, the sudden provocation by deceased has resulted in the incident in questions. Here, my case is also, my lord, same as that, my lord. He was, my lord, the abused and, my lord, the teased by the deceased, and suddenly, my lord, he lost his self-control, and due to sudden provocations, my lord, the incident was occurred. And the paragraph 13, I'm reading only the relevant line, my lord. The incident is a result of sudden and grave provocations by the deceased, since the body come to the transported by the accused to a different place in order to hide the offense, so and so, hereby convicted under 304 part 1. Here is also, my lord, it was converted to 304 part 1. My lord. Here, my main case is, my lord, the loss of self-control and the provocations. That's why, my lord, I'm asking for, my lord, the 304 part 1 to conversion of the case, my lord. From the evidence also, my lord, is pretty clear-cut, my lord. There's his previous conduct, his past conduct, and he asked for, my lord, the VRS, my lord, that was also granted. On the last occasions, my lord, he is going to be retirement, my lord. He did not be doing, my lord, such type of incident, but he lost his self-control and he did, my lord. So may I pray, my lord, the going through the, my lord, entire evidence, my lord, my conversion into, my lord, 304 part 1. That is my humble submission before lost. My lord.
Query. You see, this is not an appeal.
My lord.
In an appeal under the BNSS now, and even under the CRPC, the power of the appellate court is coextensive to that of the trial court.
My lord.
Now, in these cases where there's a trial by the army court,
My lord.
how far that interference can be made in exercise of power under Article 226
My lord.
to reappreciate the evidence? How far, to what extent we can use our powers?
My lord, here, my lord, the 220 is the ample power, my lord. Because, my lord, they are not proceedings under the CRPC. They have conducted by their, my lord, BSF rules and that BSF Act and rules are, my lord, 226 is there, my lord, to, my lord, the pass an order, my lord. Because they are doing all, my lord, the BSF Act, my lord.
There will be BSF Act. Border Security Force Act. Which was that provision 226?
My lord, the 41s of Rule 41, my lord, trial of cases either by the Security Force Court or Criminal Court. The Rule 41, my lord. My lord, there is, my lord, equal power, my lord, the Criminal Court and the Security Force Court has, my lord, equal
Yes.
power. My lord.
Yes.
Rule 41, my lord.
Lordship is
Yes. After that, about 226, power under 226.
photo করেছি না? মই photo করেছি। It's I have already quoted also in my affidavit, Lordship.
এই কথাটা কৈছে নি পাৰে পাৰে বুলি আছে নে কি বুলি আছে মই এফিডেভিটত কি বুলি আছে
এখনো আছে ন section adjustment of jurisdiction. Page 202.
Hmm?
Page 202, extra for group 41 and 40.
34 না ইনার পেজ 34
In our page 34.
এটো চয়েস অফ জুডিশন বিটুইন এটোৱে রুল
সেইটোৱে।
রুল 41 42 of the BSF rule. তো এফিলিয়েট কোড কোনটো তো এফিলিয়েট কোড নাথাকে আৰু
Nine, nine, sir.
হাইকোর্টে হ'ব
তাই না repeat bila.
হ্যাঁ?
Supreme Court যায়।
হ্যাঁ।
Court of Appeal Supreme Court যায় না appeal হয় আর
Yes.
তো ওডিসা সবে ওডিসা
Please come to rule 167.
My lord. 167, my.
Yes.
Petitions against findings and sentence of court, my.
So here they are permitted to put one petition before confirmation.
My lord. That confirmation petitions we have already been filed, my. That is at page 157.
One,
That my lord, the confirmation petitions that we
Yes.
have filed, my.
okay.
That is at page 157. Annexure 16, my lord.
Okay.
That is under section 117 2 of the BSF, my lord.
This court is called the Force Court.
My lord.
What is the name of the court? Force Court.
General Force Court, my.
General Force.
General Security Force
General
Court, my.
Security Force Court.
General Security Force.
Force Court.
Court.
The next option is, my lord, the High Court. There is no any other option to go before this.
What is the procedure for appeal?
My lord.
Or
My lord, after passing the order, my lord, there is a provision under 117. We have filed, my lord. That was filed, that was not allowed.
It's a G, no?
Annexure 16 at page 157, my lord.
General Security Force Court.
My lord, my lord. Initially, my lord, when the rule was that, my lord, when the order was passed by the General Security Force Court, we have filed a pre-confirmation petitions, my lord, after passing the order, say it was rejected. And again, we have filed, my lord, post-confirmation petition. That was also not considered. my lord.
Generally, Lordship, they prefer criminal appeal, Lordship. Our High Court also, there is judgments of my Lord Justice Ansari in Imphal Bench also, Lordship. Thereafter, they went to the Supreme Court also, Lordship. Supreme Court also, there are many judgments, but all those are criminal appeals, Lordship.
But why we have not filed in criminal appeal, my lord? Because at the same time, my lord, the order was passed. My decision proceeding also was challenged, my lord, in this case. Sentence as well as, my lord, I have removed from the services also. my lord. That two parties there. That's why we have filed a criminal. My lord, my lord, one part is still remain. Then again, how we came, my lord, before the, my lord, honorable court again for the service matter. It is an administrative order, my lord. My lord, yes. Because, my lord, my decision proceeding also, my lord, going simultaneously. My lord, in the same court, my lord, take my service matter also, my lord, and my criminal matters also. No, no, এটা অবস্থা এটা জেনারেল সিকিউরিটি ফোর্স কোর্টে কৰিছে দুটা কাম কৰি আছে ন অৰ্ডাৰটো কৰে আছে court order to serve. সেইটোৱেতো দিগদাৰ, সেইটো কাৰণে কথাটো উঠাইছিলে। One 40. The sentence part your lordship may see at page 148. To suffer imprisonment for life and to be dismissed from service. দুটা বস্তু কেনেকে কৰিব আচলতে ৰঙেই আছে
হৈছে কৰি উঠিও চাৰ্ভিচটো
বেলেগে কৰিব লাগিছিল মানে চাৰ্ভিচ মিটাৰটো বেলেগে কৰিব লাগিছিল
এইটো যদি তেতিয়াহে যাব পাৰিলে
তেহেঁতি পাৰে আছে ৰুলত আছে মানে খোজ কৰিব পাৰে খোজ কৰোঁতে লৈ লৈছে
Lordship. Lordship, here he had applied for VRS and on 3/8/12 he was interviewed by the
Just a moment.
yes Lordship.
To the other learned members of the bar, we may not be able to take up other matters. There is a single bench for which we have to rise. 3:30 will be rising. That's right.
So on he was interviewed by the board lordship on 3/8/12 and board acceded to his request for letting him to go on voluntary retirement will be effected from 31/12/2012 and on 14/8/2012 this incident happened lordship. Now lordship if lordship sees the evidences that already read by my learned friend lordship that page 64 65 that is PW sorry PW8 lordship. I am reading PW8 that his name is Tebijo Mere. So if lordship goes by the evidence of this PW8 lordship at page 65 that he had my learned friend had he has an argument that he had not fled away or nothing is there. That is why he was there, lordship. But if lordship go through the page number 65, lordship. So this from line number 9, lordship. I found blood on the floor of the veranda, spill all over. I saw one constable in camouflage uniform overpowered by 2-3 BSF personnel, bleeding from his head. I came to know the name of above constable as Tupe Subhas of Ekoi, and I was told that he had fired from his Insas rifle upon Constable Sagir Alam and Constable Bharaidi Giri Sinaya Raidu and injured him critically. So it's not that there is no question of fled from that place, because all the persons are there. Then also they came immediately and overpowered him, Lordship. And the next page also, Lordship, 66, he has stated that
No, but if he tries to shoot himself,
Lordship.
the question of overpowering or other things doesn't come because he has shot himself.
Lordship,
His attempt to shot because then there's no attempt to run.
Lordship,
He's there only.
he was there, but the other there is no he could not even run from that place also, Lordship, because it is in their barrack itself, and it was so many persons are there, Lordship. And regarding the premeditation part, Lordship, I want to read page number 90, starts from page 94, Lordship, that PW 10, that who has Jitendra Patil, Lordship, page starts from page 94.
No, because if there was an attempt to run,
Lordship,
he had a gun with him. It's nobody's case is that the magazine was empty. He did not try to force away his to escape. So he was there.
Lordship, because Lordship, may kindly come to page 94, Lordship, PW 10. Third paragraph, I came to know Constable Tupe Subhas some 4 years back after my posting to headquarter Koi of 13 Battalion BSF. I am from district Dhuli, Maharashtra, but I don't know which district he belongs. We had some interaction, and once he told me that he is residing in Mumbai. In 2012, he proceeded on permanent posting to 111 Battalion BSF from 13 Battalion BSF. After joining 111 Battalion BSF somewhere in the month of May or June, he called me once through my cell phone and expressed his satisfaction in 111 Battalion BSF, and also told me that he doesn't have any problem in eluding food. In the month of July, Constable Tupe Subhas had come to so-and-so as an attendant to a patient of so-and-so and stayed for about 15 days. During this period, we met each other for about 2-3 times, and whenever we met, he had consumed liquor, and at the same time, he appeared to be happy and did not tell me about any problem. On 14th August 12 at about 17:15 hours, I got a phone call from Constable Tupe Subhas from his cell number so-and-so and spoke to me for about 3 to 4 minutes. He asked about my well-being, then told me that he is mentally disturbed, and when I asked the reason, he told me that he had a fight with someone in his unit and also had an apprehend that they might catch him. So, Lordship, here it's not, he had not stated that someone had provoked him or something. His case is that he had a fight and he apprehended that they might caught him, Lordship. So this is also very important to see that whether to overcome this or to cover up this the later incident was there, because he was earlier very happy and he have not complained of anything, and then his this we have to read the whole version of PW 10, Lordship. I told him to go to Constable so-and-so, who was also posted from 13 Battalion BSF to 111 Battalion BSF. Initially he agreed, and then again asked me what to do in case if they come to catch him. So that premeditation possibly was already there. He is supposed to do an act, and that is why he had a fear that might have happened, Lordship. They might have catch him. Then I told him to go to his office in the unit for help. Further, he told me that these people are saying I was affected. So these people, Lordship, it's not that the only one person. They are saying, his case is that these people are saying I am affected with age. Then I told him how they could say, since they are not doctor and either to go to BSF doctor to get check for so and so. Check up, and he again told me that he will do something to himself. I advised him not to do such thing, and again told him to speak to constable so and so, so that his problem can be solved. Then he asked me to inform any of his family. I told him that I don't have their mobile number, so and so. So this was their lordship. It cannot be said to be that this is a case of grave and sudden provocation only, because he already have stated that this to his colleague in his earlier battalion before the incident, lordship, that these are the incident. So to get the this a situation to exception under 300 lordship, it has to be a grave and sudden provocation. Here, lordship, this is continuing lordship. It can be said to be a prolonged or sustained provocation, but this is not the very first time. It is going for a long lordship. So to exception to grave and sudden provocation, it's not a case of grave and sudden provocation, lordship. It's not only one. He knew these are the things, these are the languages used against him, and if he is listening or whatever is that is tolerating, if I say tolerating also, lordship, but it's not that only for the first time that is used. Grave and sudden provocation, it cannot be said to be a grave and sudden provocation, lordship. Because if we have to see it, that it's not the first instance. Maybe for weeks or months also after he joining, such an incident is happening, lordship. That is their lordship. And if lordship will see the judgments also, that the time of an actual occurrence of the incident and the grave and sudden provocation, there should not be any gap between these two incidents to get the exception of this section, lordship. But here, lordship, it's not only that incident. This is a happening for so many times, lordship. In one judgment is there, many judgments are there, lordship. In one recent, not one judgment of Supreme Court, which is although not reported, lordship, this is also a case where the army personnel had killed his senior officer by same INSAS rifle, lordship. And here this 302 was not converted. It is already Supreme Court had retained it as 302. Say that although because the incident, actual incident and provocation, there is around 6-7 hours of delay. Here also, lordship, it's although on that date it may be not on, there may be no gap, but actually it is happening for such a long period of time. So that has to be considered, lordship. So this judgment here also, lordship, same INSAS rifle has been used, lordship. And it was dismissed, lordship, by the Honorable Supreme Court.
Which paragraphs?
Lordship, it was discussed by paragraph 19, that is the last paragraph. And paragraph 11 is also there. Ingredients of exception 1. Paragraph 11, 18, 19.
Okay. The submissions of Mr. M. Furkan Danad, counsel for the petitioner, as well as Ms. B. Sharma Lanad, CEC for the respondents is concluded. The subcourt awaits verdict.
Original record আছে
Yes. Acha, before that, you're right. The letter CGC has handed over the records of the trial. Say trial before the
General Security Force
General Security
Force Court.
Force Court. Okay.
Much obliged.